rebuttal. If you wish rebuttal time, please let me know, and I will try and help you keep count. You may proceed.
If it pleases the court, I would like to hand each one of you one exhibit that I've already given to you.
And your name, sir?
Kenneth Taylor,
Thank you.
pro se as the pro se for this.
Yes, you may approach the bench.
Thank you.
Have you, the other side has
Yes, I've
seen it?
already
All right,
given her that.
thank you.
Thank you, Justice. I am humbled and honored to be here today before this court, and I appreciate the time and the opportunity for me to argue on behalf of my home that I've resided in for 29 years today. With that said, I believe this case is all about the trial court erred, especially, first and foremost, the Taylors canceled this loan in 2008 in a private transaction. This was a private transaction. We canceled the loan on July 10th of 2008. This loan was canceled. The loan was canceled by the mere fact that we mailed it. We dropped it in the mail, and that canceled the loan automatically.
Can you explain to me what you mean by cancel the loan?
We rescinded the loan. There's a law under USC 15 USC 1635, and it allows you to cancel a loan. It has a 3-year window and up to a 3-year window to cancel the loan. You simply have to send a letter to the lender, the law says, to cancel the loan. You have to do nothing else.
So then you have to leave then too? You rescind the loan and then you vacate the premises and get out? I mean, it's a loan on the house, right?
Yes.
So then if you rescind the loan, then you leave?
No, you rescind the loan, and the lender is supposed to give back everything that they forwarded to you. The money, the fees we paid, the closing costs and all that, they're supposed to return all that.
So you live there for free all that time?
No, you don't live there for free. No, absolutely not.
But they're supposed to give you back all the money that you paid to them?
Yes, that is the law.
Isn't that living for free?
No, you can't live for free. It's not living for free. It's that because the lenders didn't follow through with their obligation, it canceled the contract.
Okay, what did the lender not do? That
The
they
lender
supposed to
didn't
do?
provide the disclosures, and
Okay, all right.
they didn't provide the necessary disclosures that we asked for.
Well, that you asked for or that the law requires?
That the law requires. The bottom line is that when a borrower exercises his right under 15 USC 1635, the right to rescind a loan or cancel a loan, all he has to do is send a letter to the lender and says he wishes to cancel. I know it's a very hard and harsh law for judges to accept and lenders to accept, but it is in fact the rule of law. By operation of law, once a lender mails this notice, the loan is canceled. Now the lender can come back and say, oh no, you can't do that, but the law only gives them a 20-day window. And that 20-day window they have to file a lawsuit. And if they don't file a lawsuit, then the loan is canceled and there's nothing anybody could do about it. It's just the law. The law was under authority of 1635, and then it's also under the authority of the United States Supreme Court, where Justice Scalia delivered in a terse opinion. He delivered a scathing ruling that says all you have to do is drop the letter in the mail. At that point, it's canceled. There's nothing else to talk about. If judges don't like it, if lenders don't like it, it has to be addressed through the court. No one else can change that law. He said it's not to be reinterpreted, nothing to be added to it. It's just the law of the land. It's the highest ruling in the world. It's the ruling by the United States Supreme Court in Janowski versus Countywide.
Let me ask you a question. I'm looking at 15 USC 1635, and it says within 3 days. It doesn't say 3 years, it says within 3 days. You can rescind it in a consumer credit transaction within 3 days. You have the right to rescind the transaction until midnight of the 3rd business day following the consummation of the transaction.
If you go on further, there's also a 3-year window, and that 3-year window was decided and authorized by the Supreme Court of the United States in January 1st, I think, of 2015. So it's new language of the law. I don't even think the appellate court has had time to address the ruling by Judge Scalia. And it was a unanimous decision by all 9 justices who wrote that the window can proceed to a 3-year window if they didn't disclose the things they needed to disclose. And there's no argument here. The loan has been canceled. And so when the loan is canceled, it made the security instrument void. The security instrument is not voidable, not to be talked about. It's just completely void. There's no security instrument left. The Taylors have canceled this loan. It's a private transaction. It really has nothing to do with the court. We canceled this loan. And the law says that
you haven't finished paying for the amount that you bore.
you don't have to pay if there's no loan contract to pay anymore. The loan canceled.
So
That
you
was the-
you can sign a note for $100,000, which you then use to buy a house. And at your discretion, you can cancel that loan and walk away without paying the balance?
That is the law. I didn't write the law. I didn't make the law. 9 Supreme Court justices decided that was the law.
Where does the law say that if you cancel the loan, you are forgiven the balance of the payments and don't have to continue paying?
That's tied up in the wording when you cancel the loan and the lender now has the opportunity under the law to object to that cancellation of the loan by simply filing a lawsuit within a 20-day window. And if they file that lawsuit, then there can be litigation saying, and come to court and prove that you still owe the amount.
Let me ask you a question. How do you explain the section in the law that says that the section does not apply to residential mortgage transactions?
Because this wasn't a residential mortgage transaction. This was a refi. And 15,
Refinance of a mortgage transaction?
yes, this wasn't a mortgage. What did you just say?
I mean, it says a residential mortgage transaction, so you were refinancing a mortgage transaction
No, this was a refinance of a loan
for a
transaction.
mortgage.
Yes, but what I'm saying is that in the refinance, this law occurs for refinance. You can't do this if you purchase a house outright.
Okay, how about the next section that says it does not apply to a transaction which constitutes a refinancing?
Well, I mean, that's for the justices to
Well,
decide.
that's what the law says, that's what, I'm looking at 1635, that's what you said, under section E2, it says, this section does not apply to a transaction which constitutes a refinancing of the principal balance then due on any accrued blah, blah, secured by an interest in the same property. So a refi would be the same as an initial residential loan.
Was that under the recent Janoski countywide, the recent?
Well, this was, the last time the statute was updated was, looks like July 2010. I'm just trying to figure out where do you get the right to do that, because it sounds like a good idea.
2010 then makes that law invalid because there's a new law. And the law has changed under Judge Scalia's decision.
Well,
And
the statute hasn't changed. I mean, there may be some case law that modified it in some way, but the statute says what the statute says, that they haven't changed the statute. So,
And clearly, I understand how,
Excuse me, you have 5 minutes left if you'd like to reserve that for rebuttal.
yeah, I'll leave my time for rebuttal, but I'd like to ask for my prayer for relief. Under the authority of the United States Supreme Court and Janoski versus Countywide and 1635 Regulation Z, this authority is derived for us to cancel the loan. My prayer for relief is this court remand this case back to the trial court for hearings on this matter, or go a step further and review this contract under de novo and make a decision to dismiss this case. And I'll save my minutes left for rebuttal.
Your Honor, my phone is just my stopwatch for purposes, so that's why I have it on the table. May it please the court. My name is Chrissy Dutton. I represent the appellee Deutsche Bank National Trust Company as trustee for the certificate holders of Soundview Home Loan Trust 2006 OPT2 Asset-Backed Securities Series 2006 OPT2, who I'll refer to as Deutsche Bank during the remainder of this argument, or Deutsche. Deutsche requests that this court affirm the trial court's confirmation entry of sale and distribution of proceeds for the following 2 reasons. One, first and foremost, the sale complied with the requirements of sections 2329.01 through 2329.61 of the revised code of Ohio, which is the only issue properly before this court on the appeal. And secondly, even if considering Mr. Taylor's substantive arguments, which we believe are unsubstantiated and have previously been addressed by this court, they are also unsupported and have been previously rejected. As a preliminary issue, the standard of review for this case is abuse of discretion. Mr. Taylor articulated several standard of reviews, but the trial court's confirmation of a foreclosure sale is reviewed under the abuse of discretion standard. Secondly, this court could deny Mr. Taylor's appeal alone for his failure to cite to the record in various portions of his brief. It's not this court's duty to search the record for the areas that support his arguments or the allegations that he's making. And Mr. Taylor has failed to identify any portion of the record supporting his arguments. So the court should dismiss the appeal for this reason only. A brief discussion of the facts and procedural history, which this court should be, is well known to this court based on the fact that this matter has twice been appealed and remanded. This is the 3rd attempt of Mr. Taylor to use this court to stall the foreclosure process, which has now been going on for some 9 years after the suit has been initiated. This mortgage and promissory note were originally executed on February 6th, 2006. At the closing, the Taylors received the signed truth in lending disclosure, which were attached as exhibits B and C in the record at 253. In order to secure the repayment of the note, they executed the mortgage, and that mortgage was assigned on June 29, 2007 from Sand Canyon to Deutsche Bank. No payments have been made on this loan since March of 2007. And on May 4th, 2007, the Taylors were mailed a notice of default in order to comply with the pre-acceleration requirements of the mortgage. On November 30th, 2007, Deutsche Bank filed its foreclosure action. After being granted summary judgment by a foreclosure decree in 2010, and after this court twice affirmed Deutsche Bank's entitlement to foreclose on the property, a foreclosure sale was held on August 21st, 2015, almost 9 years after the filing of suit. Turning to the first argument, again, the only issue potentially before this court is not the rescission issues that were addressed by Mr. Taylor, but rather whether the sale complied with revised code sections 2329.01 to 2329.61 inclusive, which provides that if those sections were met, then the court shall direct the clerk of the Court of Common Pleas to make an entry on the journal that the court is satisfied of the legality of such sale, and the officer to make the purchaser a deed for the lands and tenements. Objections to a confirmation of sale are therefore limited to a determination of whether the sale failed to comply with the procedural matters set forth in that statutory section. Mr. Taylor has failed to argue any procedural deficiency with the foreclosure sale, and instead tries a third bite at the apple to re-argue long-decided issues pertaining to the foreclosure decree. These arguments are improper and should be rejected by this court because the party may not challenge the trial court's judgment of foreclosure in the confirmation phase of a foreclosure. In his brief, Mr. Taylor also argued that the judgment was dormant, and again, he indicates that this assignment of error was meant to contest the sale portion of the foreclosure, but he failed to raise any issue regarding the requirements of 2329.31 or articulate any reason why the judgment was properly dormant. Dormancy does not destroy the validity of the judgment and does not remove or discharge the judgment, which was properly granted here. The second argument is, even considering the substantive issues that were raised attacking the original judgment by Mr. Taylor, every argument has already been previously ruled upon numerous times by the trial court, and this court should not need not be revisiting those arguments. To address the rescission argument that was made by Mr. Taylor, this argument was treated as a counterclaim, and Deutsche Bank was granted summary judgment on that claim in the trial court's August 17, 2012 order. Taylor appealed that order, and his arguments were ruled upon in Taylor 9th District number 26626, which is 2013-Ohio-4278. As the court previously affirmed the trial court's decision for summary judgment as to the counterclaims, the Court of Appeals should not revisit this argument here. For ease of discussion, the first, 5th, 6th, 7th, and 10th assignments of error are addressed simultaneously here. And again, they repeat the argument that Deutsche Bank is not the proper party to foreclose. The time to raise this potential defect was in the trial court judgment phase, which again has long passed. Third, Mr. Taylor also raised an argument in his briefs that the trial court was required to conduct a hearing prior to confirming the foreclosure sale. There is no such requirement under Ohio law. The decision to conduct a hearing prior to confirming a foreclosure sale is within the sound discretion of the trial court, and despite Mr. Taylor's arguments to the contrary, due process does not require a hearing prior to the confirmation of sale and foreclosure proceedings, and this assignment of error should therefore be dismissed. In the fourth assignment of error, Mr. Taylor alleges that the trial court erred by substituting the plaintiff in this case. This appears, no party has ever been substituted for the plaintiff in this case. It appears that Mr. Taylor has taken issue with the trial court's abbreviation of the long Deutsche Bank name that I indicated at the beginning of this as Deutsche Bank. Taylor has cited no authority supporting an argument that the trial court may not abbreviate a party's name in the caption of an entry, and therefore this argument must also be disregarded. Mr. Taylor next argues that the trial court's denial of what he refers to as 13 motions filed prior to confirming sale without explanation from judge or a responsive pleading or answer to motions by the plaintiff. He is referring to the December 10th, 2015 order where the trial court denied multiple motions filed by the Taylors after the trial court docketed its August 19th, 2015 order. Taylor has failed to provide any legal authority supporting his belief that the trial court erred in overruling his motions. Taylor has the burden of proof for affirmatively demonstrating error on appeal and has not provided any citations to prove that the court was improper in overruling these motions. The next argument that Mr. Taylor has made in his brief is again going to issue with the trial court's alleged failure to take discovery. Again, as mentioned earlier, this argument would have only been proper prior to the judgment and decree of foreclosure. At this late stage of the game, it's no longer should be considered by this court. For the foregoing reasons, Deutsche Bank requests that this court affirm the trial court's confirmation, entry of sale, and distribution of proceeds as set forth in the December 10th, 2015 order. Although Mr. Taylor has repeatedly argued to the contrary, that is the only issue before the court. All the other issues have been previously decided and rejected by this court, and properly so. Thank you.
Thank you. You had more time if you wish to use it, but,
I think I will be in a position.
all right,
Thank you.
thank you. Sir, you have 4.5 minutes for rebuttal.
Okay, thank you. The plaintiff's attorney mentioned the sale of this property, but she failed to mention that not one single dime was put up. No one paid a penny for the price of the sale at auction. There's no financial transaction on the record anywhere where anyone rendered any money in this case at any time. Throughout the 9-year history she mentions, the single most profound issue in this case is that Deutsche Bank filed a lawsuit against the Taylors in federal court with Judge Sarah Leo in 2006, I believe, and that ruling is in the record as an exhibit. And Sarah Leo said that the plaintiffs lacked standing to bring these issues to court. They had no interest in this loan at the time of filing. The assignment they created was created by the infamous docs, the robo-signing. They created this assignment only to go to court, but they created the assignment before they had interest in the loan. They filed the lawsuit. The judge just said that the assignment is defective and they lack standing to bring this case. That could never be cured. So they brought the court into state court here after it was dismissed in federal court for lack of standing, and they used that same assignment that was not a reflection of what the true story would happen, because that assignment at the time they made it, they didn't have interest in our home. We don't know who Deutsche Bank is. When we canceled this loan, by evidence on that Exhibit A in front of you, it says that option 1 is the alleged lender. Deutsche Bank had already said that they owned the property and filed a lawsuit. So either option 1 transferred to Deutsche Bank, and Deutsche Bank transferred it back to option 1, and option 1 then answered the cancellation by acknowledging the fact that they received it, the cancellation of this loan. We don't know who a lender is in this case. No judge can say factually that they know who the lender is in this case. Not the trial court judge, not the plaintiffs.
Has the trial court judge expressed that in a written filing or a document, or are you just assuming?
No, we filed a motion asking for them to identify the lender, and no one has done that. No one knows who the lender is. That's why this case has been trickling on for 9 years, because they have a burden of proof to prove that they paid the money. No one has injury here. These parties, basically Deutsche Bank is a stranger to the loan by the fact of the way that no one knows who they are. And they won't come to court. We haven't seen a live body in this case for 9 years. Not a chief executive officer from the bank, not a chief executive officer from Deutsche. No attorney has ever showed up. It's 100% paper case. No live bodies, no hearing. There's no evidence whatsoever that anybody lost a dime in this case.
And you are now over your time and must conclude.
Thank you.
Thank you for being here. We'll take the case under advisement and we will send you a copy of our